the appeal in the matter of W children?
Yes, Mr.
May it
Becky.
please you, my lords.
Yes,
Lord, in these proceedings, I, together with Miss Rebecca Littlewood,
yes,
appear on behalf of the first appellant mother. She sits at the back of the court to my left.
yes,
The second respondent father is represented by my learned friends Mr. Nuvoloni, King's Counsel, and Miss Bewley.
yes,
The first respondent local authority is represented by my learned friends Mr. Christopher Poole and Miss Jemima Hendrick. And the children appear by their guardian,
yes,
by my learned friends Mr. Mark Toomey, King's Counsel, and Mr. Tim Hussain.
yes. And just to remind you, the child's name is not to be mentioned.
Indeed.
We will simply call him Jay, and the mother and the father will be referred to by those designations.
Yes. And we're all well aware that because of the nature of the proceedings, there is an overall general anonymity provision in
Yes.
relation to the reporting of these proceedings.
Now, I can tell you that we have read the skeleton arguments, we've read the judge's judgment, we've read a number of witness statements, and we have some familiarity with the authorities.
Most obliged.
Can I inquire, have you divided up the time between you?
We have had a go at that. I can tell my lord that my expectation is that I hope to conclude within between 60 and 70 minutes. My learned friend Mr. Nuvoloni has indicated 50 minutes.
50, yes.
50. Learned friend Mr. Poole's indicated something between 45 and 60.
Right.
Learned friend Mr. Toomey mentioned to me a few moments ago 15. I don't know whether he was being serious. So I would imagine about another half an hour to 45 minutes. He will stand up if...
Well, we have a very full skeleton argument.
Yes.
From him, so maybe he doesn't need to add very much more. And then you've allowed time for replies.
Yes.
Fine.
My lord, just in terms of practical matters, bundling, there's a core appeal bundle which I think runs to 2 lever arch files. I think most of us are working from a digital copy, so I'll try and give the PDF numbers as well, if that's possible when we go through.
Well, I'm afraid I'm a dinosaur. I'm working from paper.
There we go. There is obviously an authorities bundle, and then there's latterly, after some wrestling with the CFC, a transcripts bundle which contains the evidence, the oral evidence of the 3 experts and the parents.
Yes.
The mother's evidence was not available digitally, so we have agreed a note for evidence which is in the bundle.
I've seen that. Thank you.
My lords, this is an appeal against the findings of fact made by His Honour Judge Marin, sitting in the CFC following a fact-finding hearing. His judgment was handed down on the 16th of September. His judgment is at page E1 in the bundle, PDF 186. An application for permission to appeal was refused on that day, but was renewed to this court by application on the 3rd of October by the mother, and the father filed his own notice of appeal. Both applications came before Lord Justice Baker and were granted on paper on the 23rd of October. By just way of general background, these care proceedings are fixed for a final hearing at the end of March of next year. And my understanding is that there's generally a plan for the rehabilitation of the children to the care of their parents, and that's underway, and there's an ongoing assessment in relation to that. The grounds of appeal filed on behalf of the mother are at A1 in the bundle, PDF 5, and there's a perfected skeleton argument dated the 1st of November at page B1. My lords, may I just say by way of introduction, and I will be brisk in my opening remarks, we do not seek to gloss over the obvious hurdles faced by any litigant seeking to appeal against findings of fact. The applicable principles are fully and accurately set out in all of the skeleton arguments, with particular emphasis on the Fahey, brackets yogurt case, and Volpe. And I don't seek to go behind any of the learning which emanates from those decisions. And as my lord will have detected, as we say, the judgment was in many respects of very high quality, certainly in terms of its structure and its thorough analysis of the expert evidence, and in its overall clarity of expression. However, we do submit that the very hinge of the analysis, in his assessment of the evidence of the mother, the judge fell into error in the ways we have articulated in the grounds of appeal, amplified in our skeleton argument. My lords, I'm just going to deal with the background very briefly to set the scene, if it's of assistance. It should take about 2 or 3 minutes.
Fine.
Well, it's the morning of the 24th of April 2023, at about 7 a.m. The mother was present in the family flat with the 2 children. The father had left for work. The child J, that time, was about 8 months in age and had just begun to toddle. And his brother H was almost 7 years of age. The mother went into the kitchen, and J was within the landing area leading to the kitchen. The mother saw J attempting to pull himself up on the left corner of a radiator affixed to the wall of the landing. He lost his balance, and the mother says that he pitched forward head first and fell, so that his head came into contact with the left corner of the radiator, and then, as part of his descent, on his way down, he came into contact with the wall adjacent to the radiator before falling onto the floor, where he ended up lying face down. Thereafter, the mother observed a reaction whereby his body jerked in all 4 limbs for about 20 seconds, and then he began to cry out. The mother called the emergency services on 999, who indicated they could not send an ambulance, but would send a taxi instead. She then called 111, and a video assessment was undertaken of the child by that responder. The mother then took him to hospital by taxi. In the immediate aftermath of the fall, the mother took a number of photographs of the injury. And they're obviously of some importance. In the hospital, further photographs were taken. During his stay in hospital, the injury developed in its presentation from a large swelling over the right side of his forehead to significant bruising around his right eye, over time spreading to his left eye. The evolution of his symptoms was documented pictorially by the hospital over the following days, and he was discharged on the 27th of April. Lords, he was ultimately diagnosed as having a subgaleal hematoma, an unusual injury to the head or scalp caused by the shearing of vessels bridging the subgaleal space. On the 26th of April, he was reviewed by the ophthalmology team who examined his eyes. It was noted that because of the very significant bruising and swelling with his right eye swollen shut, it was difficult to examine him. New subconjunctival hemorrhage, no subconjunctival hemorrhage was detected insofar as it was possible to examine the eye in view of its condition. No safeguarding concerns were raised by the clinicians in relation to the account given of the fall by the mother. And then, very briskly, the chronology records that Jay fell again on the 27th of April following his discharge. He returned to nursery on the 2nd of May. On the 3rd of May, he was taken to see the GP because the mother noticed he had gone off his food and become fussy about his milk. The GP records that he told the mother to take the child to A&E immediately and prescribed antifungal medication. The mother's case was that she had no recollection of being told to take him to the hospital immediately, and that she had thought he had been prescribed an antibiotic form of medication. There was a further bump to the head recorded on the 4th of May, and on the 6th of May, Jay suffered what was subsequently found to have been an allergic reaction to blueberries in the porridge that he had for breakfast, whereby his lips suddenly turned blue and he became swollen and his breathing became heavy. He was taken back to hospital, where he remained under observation until the 17th of May. He was finally admitted to hospital on the 5th of June, the mother having reported that he had sustained further facial injuries in the form of a graze and a bruise to his head, and he had made that and had made the assumption that he'd either bumped his head on a musical box affixed to the side of his cot or on the wooden cot itself. It was this last admission to hospital that prompted the child protection investigation, the view being taken that the constellation of marks and injuries to his head and the identification of a subconjunctival hemorrhage at that time to the eye after the last admission presented a picture of inflicted injury. At the hospital, after a long wait, the mother left the hospital for a period of time. When she called in by telephone, upon being told to return, it was recorded that she expressed herself as being reluctant to do so. And there took place a conversation between the clinician and the father, which the judge recorded in the judgment at paragraph 56. I won't take my lords there at this point. This episode seems to have fortified the safeguarding concerns, and the proceedings commenced in the aftermath of those conclusions. So within these proceedings, there were instructions of 3 experts, Mr. J. Marin, a consultant paediatric neurosurgeon, Dr. Levy, a consultant paediatric ophthalmologist, and Dr. Cardwell, a consultant paediatrician. the local authority sought findings of inflicted injury in relation to all of the injuries detected and identified between the 24th of April and the 5th of June, findings in relation to the failure to seek timely medical intervention after the GP appointment on the 3rd of May, and in relation to the parents' conduct at the hospital on the 5th of June. But the main focus, it's fair to say, of the fact-finding hearing was, however, was upon the issue as to whether the injuries were inflicted or not, and if so, by who. My Lords, it is fair to say that it's formed no part of this appeal that there's any criticism made of the learned judge in his recording and analysis of the expert evidence placed before him. And we will see in particular, and it's, my Lord's note, his review of Mr. HHJ Marin's evidence at paragraph 94 of the judgment, E13, PDF 198. I remind the court that all of the experts had seen the photographs of the injuries and of the property itself, including the radiator. And learned judge accurately sets out his conclusions as to the medical evidence in relation to the head injury, which are not controversial or challenged, and indeed broadly in his judgment between paragraphs 109 and 124 reflected the submissions made on behalf of the parties. There was a controversial finding on the one isolated subconjunctival hemorrhage, which he sets out at paragraph 125. My Lords, in laying the ground for what we submit is the principal ground of this appeal, which is really ground 2, it's probably going to be instructive just briefly to glance at the photographs before the learned judge. And we find those in the main core bundle at section J. There are many photographs in this bundle. I'm not going to take my Lords to anything like all of them. But if I can begin perhaps at J165 to set the scene. So I hope that J165,
Yes,
which is PDF, I think 689.
this is the radiator.
It's the radiator, and it's the only picture that we have of the radiator. It's
There's another one actually. There's another one at 141.
141.
But this is much the same photograph, so it doesn't really matter. If you want to use 165, fine. Just explain, if you would, how does Jay pull himself up on this radiator?
So,
Doesn't seem to be much of a handhold if you look at it.
well, my Lord, the first point to record is that the covering, which
Wasn't there?
wasn't there. No. So he could, I'm not sure this was explored fully in evidence, but he could have pulled himself up by grabbing onto the side of it. Because without his hands coming around the front onto the side of the radiator to pull himself up. As my Lords can see from the part of the radiator, the rear section, which is not covered by the protective covering, there's a ridge. You can just see it at the top. Mm. There is a ridge which would, if seems likely, replicated on the front part of the radiator, would be something upon which he could have taken hold to pull himself up. So that's the radiator. Well, just so that it's done, I'm just going to invite your attention to some of the photographic evidence which demonstrates the evolution of the injuries. And again, I can do this briefly. There are about 5 or 6 of them. But if I can take my Lords back to, I think, J7. And this is just to set the scene. This is the day before the accident. 2 days before the accident. So J7 and J8 before the accident. And then we have at J11, the photograph, which was the first photograph taken after the accident, showing the large swelling to the right side of the forehead.
Yeah.
And importantly, making reference to the two cuts or graze marks, which seem to be straight and in something of a parallel with each other at photograph 11, and then just turning through, you see a number of photographs there taken in the aftermath of the injury that morning, right until J16, when he's obviously in hospital.
Yeah.
And then 16 to 22 are photographs in the hospital. And then in terms of the evolution of the presentation of the injury, we're assisted by photographs taken over the next few days. So on the following day, the 25th, at J24, you can see the beginnings of a black eye on the right side. And then, and over the next few pages, we see the development of that right through to the 26th of April. Those photographs begin on J30. And so we have at J34 to 39, the emergence of bilateral bruising. So the other eye has now
Yeah. By J37, he's gone home.
yes. Indeed, my lord. And you get a good view of the bruising, which you on at J39. You can see that. Insofar as its assistance, while we're here, just to colour off dealing with the photographs, there is a photograph taken on the 5th of May, J62, somewhat later in the piece, but this is the day before these are 2 days after he went to see the GP, the day before he was taken to hospital with the allergic reaction. And then at J64, that's child in hospital on the 6th of May. And then others may refer you to other photographs, but just to complete this, J139 is an image of the child on the 5th of June at the point of his last admission, J139.
Sorry, which date did you say this was?
5th of June.
Yeah.
And that was the admission which prompted the referral.
That's the third admission.
5th of June, 2023, 139, and he's in hospital there. And this is following what the mother has assumed was his head coming into contact with part of the cough, or the musical box. So far as the mother's description of the fall is concerned, my lord asked about pulling up. In fact, if I can take my lord to G20, PDF 465.
G20. This is father's statement. Is it?
It's the mother's statement, my lord. It starts at G18.
Yes. Yes. G18 is where. Oh, I see. I think I just got two lots of numbers. Right. G18. I've got that mother's statement. Yep. And 20. Yes.
And then G20 is her account.
Yeah. It's paragraph 17.
Yes. He tried to pull himself up on the left corner of the radiator.
Yes.
think we need to read that with what she says at paragraph 1 of the initial statement.
Yes. And we accept there is a difference there, particularly in relation to the use of the word valve.
So if we just compare that with the photograph we've got at J165, he tries to put himself up on the left corner of the radiator, so that's the corner, not the side. And then he loses his balance, fell onto the side of the radiator, that's presumably the left side, and that. And then there's a small gap between the edge of the radiator and the doorway,
Yes.
and that's the bit of the wall where he hit his head.
Yes. The mother was asked to give an account in oral evidence in relation to this. Now, we now have it in the transcript, in the transcripts bundle. And at T transcript 93.
Yes.
And we see at the second paragraph down, I got the boys up to get ready for school, to start to get ready for work. In the kitchen, I was in the kitchen when Jack was in the landing bit. He pulled himself up onto the radiator, lost his balance, hit the corner edge of the radiator, then went into the wall and landed next to the wall and the floor. He didn't lose consciousness. I called 999 for them to send an ambulance. They didn't send an ambulance. They accessed my phone to see how he was, and then they sent a taxi, with which me, Jack and Harry got into and went to the hospital. Then about 2 questions later, question, can you say anything more about what happened to him as he went from standing to being on the floor, pulled himself up, went forward onto the radiator, slid down wall with his head and landed on the floor? Question, are you able to see what parts of the body had come into contact with parts of the house as you've described it? And then 4 lines down, what did he come into contact with? It was literally just his head. What did he come into contact with? The radiator, the wall, and then landed on the floor. And then the question, the word he used a moment ago was sliding. What did you mean by that? Once he came off the radiator, he landed against the wall and slid down the wall, and landed right next to the wall straight radiator on the floor. And then there's some questions about the photographs. So that was her description of what she saw in evidence in chief.
If you're leaving that, of course, she was then asked about the radiator valve, wasn't she?
Yes, and so, well, if I can just skip forward 2 pages to page 95, she's asked about the radiator in the context of the photograph. So photo 16, this is about 6 lines down.
Are we still in chief here?
In chief, yes.
Yeah.
Photo 165, is this the radiator? Yes. Is this a photo you took? No. Is it a police photo? I believe so. Is the radiator relative to the April 4? Yes. Does it look like that? No. Didn't have any firm edging on. Look at the radiator now. Can you point to where it was you say Jack fell? Mum points, there's a comment from the note taker. Mum points to just on the corner, middle of the left-hand side of the radiator.
Can we call the child J, please?
Of course, Mother. Did I not?
Yes.
Oh yes, of course. Yes. And then, in cross-examination for the local authority, she's asked some questions.
This is page 98 and following.
Yes, in relation to the account that she's given. And you will see there that at 98 she's asked about a police interview and the time when the child had begun to be able, developmentally, I think, to pull himself up. Because she's saying that he pulled himself for 2 weeks, or the weekend of the 24th, from the Easter weekend, from 2 weeks before, and it's put to her that she'd only begun to pull herself up from very recently. She said she got mixed up. And then she's asked a number of questions about whether or not the radiator was on or not. But at page 100, she says, and I think it's something she confirmed when she was being asked questions by my learned friend Mr. Hussain on behalf of the Guardian, page 100, she said she didn't know if the radiator was on or not. There was an attempt to obtain what she could remember in relation to that. She said she couldn't remember. And then there's a question about the
She
valve.
previously said she turned it off.
Yes,
Page 99.
yes. I think her final position was she couldn't remember. And then she's asked about the valve at page 100. Question, looking at your first statement, you referred to a valve. Look at the photo, assume the valve was a bit at the bottom, yes. She says he didn't hit his head on the valve, he hit his head in the corner. And put to her, the statement was a lot nearer to the incident. Are you telling us the statement isn't correct? Yes. Why is this statement not right? Because I got the words wrong that I said to them in. And then there's questions about why her statement had not been corrected. And she said that she must have misread it. So, because of what we submit are its apparent prominence in the learned judge's reasoning as to why he rejected the mother's account of the fall, we have in our ground two and our submissions in relation to that focused on the extent to which that issue was explored during the course of the trial. And it just might be of some use just to glance at the oral evidence of Dr. Cardwell, who is the consultant paediatrician, who was not asked the direct question, is there a correlation between the 2 marks that you can see on the first photograph and the mother's description of events? He was not asked that question. But it is fair to say that all of the experts had all of the photographs. At T transcript 57,
The experts gave evidence before the lay witnesses.
yes.
57.
57.
Yes.
So one is now faced with the prospect of reading out a question which is in no way clear or concise, put by me, but nevertheless, I say it. Q, F, thank you. Perhaps the simplest way to deal with this is in this way. It is a matter for the court as to whether the mother's account of what she saw on the 24th of April is accepted or not. But if the court accepts that she witnessed a fall and the aftermath of the fall and took the photographs which she says that she took and gave the explanations which she'd given and repeated, does it follow from that, firstly, that if the court accepts the account is true, that account would be sufficient to account for the presenting injuries on the 24th of April? So that was a question cast by reference to her explanation and the photographs. And the answer was, yes, bearing in mind the additional caveats that Mr. Jayamone has put around that in view of the unusual nature of the bleed and subgaleal collection itself, but yes. And then at T62, reference to the first photograph, at D. All right, can I just ask you this? The mother's account is that she took this photograph in a very short period of time from the child having sustained injuries in order to send it on to her partner. And we can see on that photograph already, I think, a significant swelling to the right side of the forehead and then some abrasive marks, including, I think, 2 points where the surface of the skin has been bruised. Is that right?
Those are the grazes.
Yes.
Yeah.
Says, yes, I would agree with that. Are you, question, I know the dating of injuries and in particular bruising is extremely difficult from photographs, but is there anything you can say to assist the court in evaluating whether or not that looks like the type of presentation of a child in the immediate aftermath of having sustained a head injury? He says this, even at this point, it's an unusual presentation because it's such a large swelling to have occurred so quickly. But yes, I mean, and you can see the progression through further photographs to show the continued development of the area of swelling, which, so yes, I mean, it would agree that it's keeping with early on after the incident. And the point that we draw from that exchange is that the expert was specifically referred to the 2 points, and that was an opportunity for him to say, if he thought this, that the presentation of that grazing and those marks was not consistent with the account given or the involvement of the radiator as described by the mother. But he didn't. So the learned judge...
Sorry, Mr. Begg, I'll just ask you this. At the point when Dr. Cardwell is giving evidence, is the mother's case that the child hit the valve or the side of the radiator?
Sorry, I didn't hear my lord, sorry.
At the point when Dr. Cardwell is giving his evidence, is the mother's case that the child hit the valve or the side of the radiator?
The side of the radiator, not the valve.
Can you tell us when she first made that change? Because the first witness statement isn't dated. The second witness statement, I think, is dated, but not till, is it July?
It's
20.
It was very recent to the hearing.
After
the
the experts meeting?
Yes.
Yep.
Yes.
Thank you. 31st July is the
Yes,
second
the
statement.
case, my instructions, if it's fair to, throughout my involvement, certainly at trial, was that the use of the word valve had been a mistake. So just now to turn to the learned judge's analysis of this aspect, at page 173 of his judgment, paragraph 173 of his judgment.
You've taken us to Dr. Cardwell. Is there anything in Dr. Marin's oral evidence where he addressed the photographs, say, on J11?
I did review that in the run to this hearing, and I couldn't find anything of similar precision or quality in relation to that. No, in Dr. Marin's. He had given a more general account that the explanation put forward by the mother in the context of the photo, in the context of all the photographs that he had seen, was a viable explanation for the injuries. And it was left at that. What he wasn't taken to was a specific point. Here are these 2 marks. Here's the radiator. What do you think? That what the question wasn't put in.
By anybody?
By anybody.
We've got what the judge says about Dr. Levy, paragraph 98, subparagraph L.
Yes.
Where he says the April injury was hard to attribute to falling against the radiator and onto the floor.
Well, Dr. Levy was addressing 2 aspects, periorbital bruising, but mainly the isolated subconjunctival hemorrhage, which was only seen on the 5th of June. And the debate at that stage was whether that, even though it was spotted on the 5th of June, the question was, could it have been a remnant from the big fall back in April? And then there was a debate as to the extent to which the clinicians on the ground would have been able to see it in the immediate aftermath of that fall. and whether or not it had come a little bit later. There was some evidence about whether or not it could have manifested a bit later and been missed, even though the child had been seen but not ophthalmically examined carefully until June, or whether it was a fresh injury.
Yeah.
And even if it was a fresh injury, did it mean very much in the overall context? Because there's a part of his evidence, we'll take Lewis to later, where he says, well, you can't really make very much of an isolated subconjunctival. You could just catch it with your fingernail. And so there were there was a couple of explanations in relation to that, which was open for the learned judge to resolve. And of course, what we say, anticipating what we'll be saying later, is that the learned judge used the primary finding in relation to the infliction of the initial injury to inform all the subsequent findings, which resulted in a global finding of a much more serious order in terms of the mother's conduct, a series of assaults over a sustained period of time, rather than just an isolated incident in June. But I set that out in the skeleton, we can come to that in a minute. So, but just going back to the photographs and the role the photographs played in the learned judge's analysis, at 173, and my lord will have seen he begins his analysis at 167 at page E25. And he reviews the account. He sets out the position in relation to the inconsistencies, or some of the inconsistencies in her account. And then at 172, he describes what the mother said in relation to the radiator and the heat of the radiator. He says this at 172, the last line. This also raised the question of whether the radiator was hot when Jay fell against it, and if it was, why mother left him near that area or did not remove him quickly when he started to topple. Obviously an area of concern for the learned judge. But then he goes on, of even more concern, and my lords will see why we have underlined those words.
Yes.
It is that picture, it is that the picture of Jay's injuries on the 24th of April does not fit with the mother's description of what happened. It shows two vertical grazes present on the head. That does not fit with falling onto a radiator nor sliding down a radiator and or a wall. And then what is really worrying is that having gone over the mother's account in various forms, considered the picture evidence, the layout of the house, I really struggle to understand what exactly happened on the 24th of April. The mother's account simply made no sense, and I'm somewhat fortified in this concern because the experts too had trouble trying to understand the mechanics of the fall. Well, I'll pause there because I'm going to address paragraph 175 in a few moments. But just in relation to 173, we can see its importance in the subsequent analysis which takes place back over at 223 at E30, when he's drawing together his concerns and reasoning to underpin the central finding that he is about to make. And so, first of all, I would have expected a normal parent to recount consistently and clearly, albeit with the odd embellishment or error, the events around Jay's injuries. Mother did not. And as I have now explained, her account of key events was often contradictory. The story about how Jay fell onto the radiator on 24th of April made no sense. The photographic evidence of Jay did not fit her description of what happened on any basis. And it's those last three words that we emphasise. And so I can come, finally, to my submissions in relation to ground 2, which we set out fully in our skeleton between paragraphs 24 and 29. But essentially, and this is, it's often said you can get too close to the trees to see the wood. But the obvious point that perhaps should have been made at trial and should have been more prominent in our skeleton was that, in fact, the two marks, quite contrary to undermining the account of a fall against the radiator, supports the account of a fall against the radiator because of the two prominent uncovered metal strips. And so any explanation or any decision would have to take into account the location and the appearance of those two marks in the context of what the mother was describing and what the learned judge could see of the radiator in the photograph.
Well, are you actually saying that if these were going to form such an important feature in the judge's judgment, then some consideration needed to be given as to whether they could be accounted for by
Yes.
the two prominent features? Because nobody did any nobody looked at them, measured them, or did anything. In other words, there was no investigation as to whether they might or might not have been caused by the strips on the radiator.
Precisely
Is that
so, my
right?
lord. And I think the reason for that, again, hands up, I think we all thought it was pretty obvious, actually, that the two marks reflected the way in which the interaction between the corner of that radiator would have operated on the head of this child if the mother was describing an event which actually took place. And the point we've made more generally is that if the learned judge, when he had reflected upon all of the evidence, had formed the view that this one point was in fact a killer point, it was something which convinced him in his own mind that his instincts as to the believability of the mother's account were right, then fairness required it to have been highlighted in advance of judgment. And because it's contrary to the overall thrust of the expert evidence, was that from what they had seen and read, that the overall account given by the mother was a viable account. There was nothing in and of its manner of description or the photographs which suggested to them that it was not viable. And the mother should probably have been questioned by a party or the court, because we've seen from the transcript, the learned judge did have the opportunity to put questions. He did ask the mother a question right at the end of the transcript, just to ask her to go over matters again, but not that question, so that she could have given an account on it. And the learned judge didn't invite submissions on it. And if he had, I would have made the point, I hope, that I've just made to my lords, which is, if your lordship's struggling to envisage it, let's see if we can help. Because it's a child falling forward onto the corner of the radiator, no cover, two prominent marks, two marks there. It might have been submitted that it's really quite easy to see how those marks might be regarded as consistent with the fall, or certainly neutral, but not wholly undermining of her account, as seems to have been the case. And we would probably, at that point, have just invited the court to pause and put some further questions in writing to Dr. Cardwell and Mr. Marin and Dr. Levy to invite their assistance on that matter which was causing the learned judge particular concern. Now, of course, I accept that listening to the evidence is not the same for the learned judge. It's not the same as taking it away, having a period of reflection upon all of the evidence, thinking time, and ideas springing up. I'm sure my lords have all had experience of that, reflecting on whether one's initial instincts in the aftermath of a trial actually find final expression in a judgment, or in the same way. So I don't even criticise the learned judge for not having raised it at the time, because it might not have been in his mind. But at some point during the formulation of judgment, it did come into his mind. And what really ought to have happened then was he should have invited further submission in relation to it, and then we could have squared the matter off in a procedurally fair way, and in not a way which has opened the door to the type of complaint, if that's the right word, which we make in ground 2. The legal underpinning of that complaint is fairly clear. I only want to rely on one authority, and it's REA number 2, which is the authority at the very front of the bundle. It was, of course, it was the only one missed out in the original formulation of the authorities bundle. REA number 2 was a decision of this court in 2019, following, well, in the middle of actually, a fairly, well, highly unusual course of litigation involving the death of a child. Following a rehearing of a fact-finding hearing, when of all the theories advanced during the currency of the case and at the trial, the one explanation for the child's death which was alighted upon by the learned judge at trial was not one advanced by any party and not one flagged up by the learned judge in advance of his judgment. And that led to similar types of arguments being raised, the one that we're raising now, in relation to that. And so I'm only going to alight on 3 or 4 paragraphs. Paragraph 75, this is the judgment of Lord Justice Peter Jackson. And the central point was, it's not fair to come up with your own case theory, which hasn't been properly ventilated during the currency of the hearing and given the parties opportunity to make representations as to whether it's viable or not. And so, what the learned judge, my Lord Justice Jackson is doing in this part of the judgment is distilling the submissions of the family. But as we will see subsequently, he did adopt this reasoning. And it's grown for, the complaint was that the judge did not show his hand. If he was thinking that an assault may have occurred at the end's home, he should have been explicit about that so that the parties could address it. It never occurred to the parties that this finding would be made. At paragraph 90, between paragraphs 96 and 98, which is A32, A31, forgive me. Learned judge in the Court of Appeal reviews the existing learning at that time in relation to the ability of a tribunal of fact to make findings which fall outside of the cases advanced by any of the parties before the court. I don't really want to read all that out unless it's persistent to my lords, because the points are, I hope, fairly clear. And then paragraph 98 was a incorporation of my Lord Justice McFarlane, as he then was in the Reed W case, making the clear point that fairness required that the case in support of adverse finding is put to the relevant witnesses, put in cross-examination, and so on. And then in relation to this case, paragraph 108, A33, just a signal there for my lords that it was against his background that the judge developed his own case theory. I don't need to read further than that. And then finally, the incorporation passage, which is at 113, A36. In sum, the substantive and procedural criticisms of the FGM finding, more fully catalogued at paragraphs 76 above, are convincingly made out. Indeed, the two sides of the same coin, had the finding sound basis in evidence, it would not have taken the party by surprise. So, what it comes to is this. It's a fairness point. It's not a point in relation to the weighing up of the evidence and all of the engaging all of the principles so clearly articulated in the host of cases referred to by others, Fahey, Volpe, G&G, going back decades. None of that. This is a fairness point that if an adverse finding is going to be made on a question of fact, which is central to the decision the learned judge is making, then there is a duty upon the court to flag it up in advance of the judgment so that representations can fairly and properly be made and further evidence gathered in relation to it. That's the fairness point. And now, just moving on from that, I note that the learned friend Mr. Toomey, King's Counsel, in his skeleton arguments at paragraph 32 onwards, very fairly concedes that the judge got that part wrong, but effectively says it didn't really make a difference. So I probably need to address my lords as to whether it makes sufficient difference to warrant the findings being effectively vitiating all of the findings made. We say it did make a difference because it was prominent, and we've underlined the words of even more concern in paragraph 173. We've underlined the prominence with which it featured his reasoning at paragraph 223. And what we really say is this: that his conclusions as to the photographic evidence were really the clinching factor for him in the case. The prominence of the findings.
This isn't a case, is it, where there is no. Is it a case where there's no basis in the evidence? I mean, the photographs were evidence before the judge. I quite understand the point that the connection between the two wasn't put.
Well, I don't think the submission would gain much traction if it didn't seem to figure so prominently. The submission I'm about to make, I hope, underlines that, because sometimes we're told to show, not tell. It's easy to show, if you're trying to persuade someone, it's easy to show them that that what you're saying is right, because it resonates much more effectively if they can see it and envisage it than if you're just telling them, it's just words. And so that photograph was effectively the learned judge saying to himself, not only am I worried, what a final point in relation to the quality of the parents' evidence, but this, literally, to use a phrase, destroys the account the mother's putting forward. This is a piece of evidence which is sufficiently significant to convince me. I can see how this doesn't work. And so, in his mind's eye, I would submit that really is the central finding that he's made in relation to that, because there are a host of submissions which were made in relation to, there's always submissions about inconsistency, and there's a host of factors there as to a person's motivation for saying two different things on what, for us, forensically are vital points of evidence, but they say different things at different times. There's a host of learning that we refer to in relation to story creep and reliability of memory and guessed men and all of that work so helpfully done by Lord Justice Leggett, as he then was. And so they're all contestable in the mind's eye of the judge, because the judge, I think one of the points in our skeleton argument said, well, the learned judge didn't cut the mother any slack. And maybe it's not for courts to cut witnesses who they fundamentally believe are not telling the truth any slack. Maybe that's not a wrong approach. But if the judge is in coming to that conclusion, not only fortified, but almost satisfied that he's not making a mistake because he can see it with his own eyes, then that piece of evidence resonates in a much stronger way than all of the other contestable parts of the evidence in the case. And if it was so prominent, and I come back to the point, then we should really be given a chance to address it.
Can I just ask you about that? In relation to the closing submissions that were made, you all prepared written closing submissions. And I think then a day was set aside for you to speak to them. Is that right? Had you all seen your each other's closing submissions in advance of that?
I think, yeah, in advance, yes.
So when I look at paragraph 26 of the Guardian's written submissions for the oral hearing day, it's paragraph 26 of the Guardian submissions. It's D8 E123.
Just catch up.
D8, electronic 123.
Yes.
Paragraph 26. When considering the mother's account, the court may be helped by looking at picture 11 of the photograph bundle. The two vertical grazes present on the swelling, combined with the description by the mother of how the fall happened, make it difficult to see how that injury may have been caused by falling on a radiator. Is that the genesis, do you think, of the judge's
Could be.
ultimate finding? And
Yeah.
if so, did you not have a chance to respond to that?
Probably, yes, that's on me. Then, if I didn't respond to it, I don't think I did respond to it. Yeah, I think with respect to that submission, it's a highly contestable assertion. Looking at the photograph, looking at the two prominent metal strips, and looking at the injuries. Yes, yes.
It's really to address your fairness point, though, in the sense that it was ventilated, this thought was ventilated by the Guardian, it appeared, to give the parties an opportunity to deal with it.
I accept that entirely. I suppose I probably ought to say that not underpinned by any exploration of the expert evidence on the point, not put to the mother by Moylan who represents the Guardian in cross-examination, but flagged up at that point. That's ground two. My Lord, may I just to conclude this part of my submissions? I note the time, and we're coming up to an hour, and I think the other submissions will be much quicker because they all stack up behind what I'm saying in relation to this. Just invite your attention to paragraph 175. Because at the end of his analysis, and articulating his concerns in relation to the mother's evidence and whether or not he in his own mind's eye could envisage it happening in the way that she said, the learned judge raised a series of rhetorical questions. And of course, these were not questions put to us during the course of the case or an argument or to the mother, but he put them in this way. If Jay wobbled and fell onto the radiator, how did he end up also sliding down the wall? But the answer to that is the mother's description, because he came into contact with two surfaces on his way down. The court can see that the corner of the radiator is very adjacent to the wall. If he was going down forward, bang on the radiator, forward onto the wall, slide down. So it might have been a valid question to have raised, but for it to have been a confirmatory concern on the part of the judge seems it seemed capable of being answered in a way which is consistent with the mother's case. Question, would he not have fallen backwards or downwards onto the radiator? Well, the mother says in her evidence that he tipped forward. So he might have fallen backwards, depending on where his weight was at the time. But if his weight was forward, then it's a viable suggestion to make that he would fall forward. There's a radiator. Why did the mother not grab him when she saw the fall start? Well, she says she was in the kitchen, and the fall happened in the blink of an eye. So again, that hadn't featured significantly or at all in the evidence, but that was something which seemed to be impelling itself to the judge's conclusion that he raised. And then the point is, if the radiator was hot, that certainly made sense from the question of what he was doing there in the first place. But by the time, the mother had been asked about the heat of the radiator for the first time in cross-examination. She'd given a certain answer, and you'll have to reflect on the answer that she gave as to whether or not the first answer is the best answer. Sometimes the first answer is the complete worst answer. When I'm asked to assist a colleague in chambers with the answer to a legal problem, and I immediately say, I know the answer to this, but 5 minutes later I've changed my mind. So that's probably not a good analogy, but she was asked about it later, and she was asked subsequently in by the Guardian, from Mr. Hussain in relation to that, and she said she couldn't remember. She said twice in her evidence she actually couldn't remember whether it was hot or not. That could be taken one way. She shifted her evidence, which is not consistent with the case, or she suddenly had a light bulb moment in the witness box, and she said, well, I don't really know why I said that. Again, those are all massive evaluation. So, and those points, the paragraph 175 factors in our submission, the analysis undertaken there sort of underpins the learned judge's whole approach to his consideration of the credibility of the mother's account. That's all I wanted to say. I've been an hour in relation to ground two. I'm going to speed up now because there are some other points that we made. we've said that the learned judge reversed the burden of proof. I accept immediately that's a bit of an uphill struggle for any advocate to convince this court that has happened. What I would really say is this: it was a funny sort of case, in the sense that at the conclusion of the expert evidence, you had two viable case theories. You had a series of assaults, or one assault and a series of accidental injuries, but within the umbrella of assault, or accident, evolution of these signs, sustained vulnerability because of the specific and unusual nature of this injury, and everything that happened afterwards in terms of injury could be explained by normal handling.
But in effect, the judge was given a binary choice.
Yes.
wasn't he? The expert said, well, there are two possibilities here. We don't know what happened. We weren't there. You'll have to do what you can with the evidence. And the only person who was there was the mother.
Quite similar. And so, in a way, and this may be the inevitable product of that binary choice, but effectively what the learned judge was saying to them was, right, over to you. I have now got to critically examine the account you gave. And the real question is, whether having put himself in that position, it was putting too much pressure on the mother to be word perfect and to articulate herself in a way which convinced him. So the point is either that by putting all the emphasis on the mother and not looking to even if he didn't accept her account, it didn't necessarily follow that these were inflicted injuries. It didn't necessarily follow. There could have been it could have been a different form of accident, one supposes. It was obviously a case that we couldn't run. And he did give himself a Lucas-type directions in relation to the motivation for lies. There's no criticism made of him in relation to that. But it's sort of putting all the pressure onto the mother to give a good enough account.
Well, not only did he give himself a Lucas direction, he considered over a number of paragraphs what reasons there might have been for not telling the truth.
Well, not telling the truth in the context of other small pieces of the wider canvas, particularly in relation to the quality of the parents' relationship,
Hospital.
what happened to hospital, yes.
What happened in response to the GP's advice. I mean, he considered all that.
Yeah. I'm not going to pursue that particular ground anymore. So the other grounds really focus on the analysis. One big point that we had made was Mr. Marin, who is, I'm sure the court is aware, extremely eminent, extremely helpful, excellent witness. The learned judge paid appropriate tribute to the quality of his evidence. And he, extremely fair, was saying, well, we can tell a couple of things. First of all, this was a very unusual injury because, I don't need to rely on the parents' account for that, because I can see it on the photographs that we've seen. I can see the evolution of this injury, which was unusual in and of it. Something strange has happened to this child, and I can see it. And his reaction to a head trauma is unusual. Okay? And that's the first thing he said. The second thing is, it was put to him by my learned friend, Mr. Nuvoloni, as just to assist a little bit in relation to the assessment of the alternative case theories. And one of the things he said was that, well, if you're asking me to consider the hypothesis of a series of assaults, a series of these head injuries, that would be really quite unusual, because this is a child who doesn't have any brain damage. So if he's been consistently being assaulted on the head in the way that's being suggested, it would be highly unusual for this child not to present with any brain damage. And so, certainly, maybe not in relation to the primary finding, but certainly in relation to all the subsequent findings, we submitted that was a vital piece of evidence, because it placed doubt as to whether it could be really said that the subsequent presentations could truly be said to be a result of an assault, or whether they were just the manifestation of routine bumps and knocks caused or sustained by a child in the normal course of moving around, a newly ambulant child, rather than something much more sinister, a series of assaults. And so that piece of evidence was leaning very heavily against that notion. And so the prominence of the first finding feeds into all the other findings, because it's really because the learned judge said, well, I found that the first, found two things. The first injury was an inflicted injury by assault by the mother, and then I've rejected her account in relation to that, and on a number of other issues. That effectively, the learned judge saying to himself, that opens the door for me to say, well, if she caused that one, she caused all the others. And that's a completely logical way of thinking in most cases, but this was a very unusual case, because this is a child who had a particular susceptibility to re-injury because of the unusual nature of the subgaleal hematoma. And so finding number one effectively infected the learned judge's reasoning in relation to all the other findings. And it does make a difference in this case, because my lord will accept the idea that a parent in a momentary loss of control might hit a child on an isolated occasion is one thing from the point of view and assessment. But the idea that a child could repeatedly be assaulted by the same parent over a series of weeks is a finding of a wholly different order and results in another type of risk assessment. So at the very least, we submit that all the subsequent findings in relation to the infliction of injury should be set aside without in any way detracting from point number one.
Is your submission that the judge doesn't address that element of the expert's evidence at all?
You know, he does.
In his analysis.
He reflects it.
In his reasoning. I know in his reasoning part of the.
He acknowledges that it's open to him to come to that conclusion, but he doesn't. He does set out the force and nature of Mr. Jaimon's advice in relation to those injuries, but he doesn't say that in this case it shifts the dial sufficiently for him to say.
Where does he deal with that in his?
Well, first of all, paragraph 94.
Sorry, what I'm looking for is in the paragraphs after where he's dealing with where the injury is caused deliberately.
Yes.
So from paragraph 201 on, where in that does he deal with the point that you're making, that Mr. Jaimon said that
it is
the subsequent presentations could be through routine.
Forgive me. So 246.
246 is ultimate conclusion.
Yeah.
I
No, I think my lord's right.
I mean, I thought that was the thrust of your submission, is that he doesn't that having decided the 24th was inflicted, he essentially decides, given his assessment of the quality of the evidence, particularly of the mother, that all the others are inflicted without considering them in the light of the expert evidence that they don't have to be. So you're putting it in the
I enthusiastically adopt my lord's analysis in relation to that. The final part was the eye injury.
May I just, before you deal with that, could you just also point us to the passage or passages in Mr. Jaimon's evidence where he talks about the series of assault,
Yes.
The extreme, the unusual sequence, which would be a series of assaults.
Yes, it is transcript, possibly T87. Yes, this is the C, I think.
C. Yes, I mean you could probably say.
Yes. If you've got a baby with this age developing subgaleal hematoma, he's probably got a predisposition. It may set him up for those babies had this and be absolutely fine. An element of the unusual nature is that In any event, he suffers a subclinical hematuria provokes a vulnerability, does it not, going on, as you say, for weeks, perhaps a couple of months. Yes, and again, I think it's clear and fair that if it's correct, it must really be rare, it must be very unusual, but there is a visual and written documentation of this, however rare, it is there in front of us. And then on the next page, there's a question there in relation to this matter he'd raised in the experts meeting, and just seeking clarification on it, 88. I just want to clarify, you raised in the experts meeting the relevance of the absence of some factors, namely intracranial injury and fracture. And he says that letter F tells us something, does it not, about the force he must have experienced in suffering the injuries to his forehead. Yes, the number, I mean, if I'm correct with my possible hypothesis, that this boy has been hit multiple times over a period of months, but I do not see any evidence of brain dysfunction. Clinically, there's nothing in the CT scan, so he's been hit enough to cause scalp injury each time, but not enough to cause anything else. Of course, that can happen, but you know, it becomes equally an unlikely event, does it not? Thank you. And that was in the cross-examination you learned from Mr. Nuvoloni, King's Counsel. May I just conclude on the eye injury? Because again, the learned judge went back to the photograph to give him the answer. I think we'll all see that in paragraph 124. So we've made the point in our skeleton simply that there were a number of hypotheses in relation to the subconjunctival hemorrhage. First of all, whether it was a remnant, and the evidence relating to whether or not it had been visible, had it been seen at various stages. Secondly, whether it would have manifested itself immediately over the next couple of weeks, and he said over the next couple of weeks, it might not have been on the initial photographs anyway. And then I think there was some evidence of the quality of the photographs until the photograph on the 5th of June. The learned judge is referring to a photograph taken on the 19th of May, and I hope I flagged that. But that is say again? J109. J109, I'm obliged. Oh yes. I'll flag it. So the point was, when was it inflicted? Could it all be part of the first episode? And then again, Nigel says 124. It seems to me that the answer is really found in the picture evidence. The picture of Jay on the 6th of June, this is the date of the examination in hospital, clearly showed Jay with the subconjunctival hemorrhage. A clear picture on the 19th of May did not reveal anything. By May, the effect of the subgleal hemorrhage was observed. If the eye was to follow the same course as subconjunctival hemorrhage should also have been present by that time. It was not. However, it seems more likely not, taking everything together, the subconjunctival hemorrhage was not present in April and May. It was a new event first observed in June. And it's certainly not clear to me that Dr. Levy was ever asked about that, and that's reflected in Dr. Levy's evidence to the court. But the other point we've made is that, and I think reference to it, is that Dr. Levy did say that he couldn't make too much of an isolated subconjunctival because of and it wasn't certainly, didn't follow that it was an indicator of traumatic insult. Lord, just within 75 minutes.
If you're right in your grounds of appeal and that the judge's judgment was unfair, do we have any choice but to send it back for a retrial?
Prima facie, no. Although there was a judgment inserted in the bundle, which for a completely different reason, but I think it was a case where His Honour Judge Robin Chowdhury gave a decision, and was subject to an appeal earlier this year. And the decision was set aside on the grounds, I think, on the grounds of fairness and procedural propriety. But because of the way in which the care plan for that child had evolved in the period of time up until the hearing, it was possible for the parties to effectively to agree to resolve the proceedings without the need for another fact-finding process. I think that was the case with the 9 interveners, or certainly I think more than 7. And so, and the last part of the judgment records the agreement by the parties.
Well, I can see if the parties agree. But I had in mind the name of the case, whose name I have now forgotten, but it was a libel case, Polish libel case, which went to the Supreme Court. And the Supreme Court said that the judges dealing with the evidence was unfair. And they said, once you've got an unfair trial, it's all got to be set aside, it's all got to be retried. There's nothing that you can salvage out of an unfair trial.
Yes. Well, I think I have to agree with that in this case. It's very unusual for a fact-finding hearing findings to be set aside and simply the.
I mean, we can't reverse the judge's findings.
No, you have to do it again. Probably on a different basis because we've got a lot of evidence now, so it's probably a much shorter hearing. But that it would be owed to the local authority then for them to take a view as to how they wish to proceed, I suppose.
Yeah.
And we will be encouraging them, hopefully with the assistance of the Guardian, to take a proportionate view in relation to this litigation, which has gone on for a very long time. It's one small child.
I just have one question. Mr. Bagchi, in relation to, could you just look at paragraph 196 of the judge's section?
Yes.
This deals with a point which, in fact, you haven't addressed us on at all. That's not a criticism, just an observation. But it's in relation to the 5th of June, when the mother is at hospital with Jay.
Yes.
Sorry, just give me one moment. Again. And the judge records that the mother had said she thought it was all right to go home. Do you see that?
Yes.
Her written evidence is not to that effect. She indeed gives the contrary impression that she was under pressure from the father to leave.
Yes.
So where does the judge get she thought it was all right to go home?
That may be from her oral evidence. So her oral evidence probably,
Given that
she would have been cross-examined on this by from Mr. Queen.
right.
Begin at page 90 of the transcripts and then scroll.
If you wish to take time, Mr. Wood, to give me the reference, that would be perfectly fine. I just when I was considering, when comparing and contrasting her account and the judge's finding or his observation, I didn't have the mother's transcript to hand.
No.
Maybe that it is there.
You will, if you just spend a few moments whilst my learned friend's addressing you.
Yes, if you could just give me the reference, that would be helpful. Thank you.
Starting at page 100.
I think it's page 113 of the transcripts.
I'm most obliged.
12, I was saying, so good.
112 of the.
112 starting.
Yeah, 112 to 113. Let's put to, is it true you left hospital, it was okay to leave? Yes. I think the hospital said you could leave. The hospital didn't say anything. They didn't advise you, no. You thought it was okay to go, yes.
Thank you.
You recall the context. I mean, this is a child who'd been in hospital a lot in the preceding few weeks, including a very lengthy stay in May. And all sorts of background evidence as to the difficulties that was causing to the family in practical terms, father not working, money problem, all that sort of thing.
Yes, no, I understand that.
Hours already. 8 hours already.
And they'd waited 8 hours already.
I understand that too. I was just had in mind what the mother herself had said in her July 2024 statement
Yes.
about this, trying to square the circle there. Thank you.
I'm most obliged.
Thank you.
Yes, Mr. Moylan.
My lord, I'm grateful. I hope in the light of the learned friend's submissions that I will be significantly less than 50 minutes.
Right.
So there are matters which I would draw my lord's attention to on behalf of the father. If I might, it's ground 10 of the father's submissions. And simply because we set out in ground 10, paragraph 246 of the judge's judgment, and that's the one that my Lord Justice Moylan identified in terms of the judge's reasoning and his failure, we would say, to address the possibilities and the evidence, the possibilities raised by the evidence of Mr. J. Moylan. It's at 246, where the judge finds that J did not have any accident or accidents. We would say the analysis is absent. He addresses in the paragraphs preceding it, paragraph 243 and 244, that is E32. It's PDF 217. The judge recognises quite rightly at 243 J's medical presentation was unusual, so unusual that it led the medical experts to offer alternative opinions, needing to be considered in its own right. But then the judge proceeds, crucially, none of the medical experts ruled out non-accidental injury caused by one or more multiple impacts, albeit by low-level trauma. Thus, the medical evidence allows for a finding that someone deliberately injured J. And he then goes on the basis of his previous reasoning, that there's more than one injury, and none of those are accidental. They're all deliberate, because that's his fundamental conclusion at 246. And we say he does that without detailed analysis. So I'd align myself with what my friend Mr. Bagshee, King's Counsel, has said. My lords, I hope will have seen from our submissions document the real thrust of father's position is that the judge was wrong to make findings about the father's state of knowledge. It's ground 8. The judge, having found at paragraph 253 of his judgment, that's E33, PDF 218. He starts that paragraph, I've referred to F being angry.
Can you give me the paragraph again?
But it's paragraph 253, my lord. E33, PDF 218. And what the judge there, and this is the significant and serious finding against the father, I've referred to father being angry. However, on the balance of probabilities, I'm unable to make a finding on the evidence that F caused injury to J. However, I do find that F was aware at some point of the truth of what happened. Now, the judge recognised in his judgment that a trawl through of the media evidence, as so often happens, is necessary now in these cases, did not in fact reveal any smoking gun. There is no communication between mother and father that was before the court at the time to support the idea that father actually knew. And in fact, we set out at B26 of our document, so this is ground 8, we set out references there, we'd set out in our submissions document to the judge, how in fact the father's behaviour, his communications, we would say clearly support the view that he didn't know any truth. And of course, the judge's truth is that the mother had inflicted deliberate injury on the child. The father's communications, we would say, make it clear that he believed, we say rightly, that Jay had suffered accidents.
Well, he makes some findings about father at 219 and 220, doesn't he?
My lord, he does. And of course, that's on the basis of the court being dissatisfied with father's painting of the relationship as being a perfect one, and he unpicked that. He makes references to the mother's suggestions about father being controlling. There's issues of what father was demanding in terms of preparation of food, how he would take things out on mother when he came back from work. And the judge goes into an assessment very much at the behest of the local authority into father's communications with a work colleague. The judge decides that actually that doesn't help him at all.
No.
And we say he was absolutely right to do that. It was raised by the local authority, he investigated it and he dealt with it, we would say, appropriately. But the findings he makes about the father's behaviour on the 5th of June, so that is encouragement of mother to leave the hospital or to come home, the father's anger on the telephone to the hospital. And it has to be said that the judge also raised a query as to why it was father was spending time away from the mother at that period in May and June on the basis of those email communications with his work colleague. But we say that the judge then took that assessment of father's behaviour on the 5th, and that led him to conclude that the only possible reason why he would have behaved in that way on the telephone, the judge identifies it as unacceptable behaviour, the father accepted that in his evidence. That is the basis, we say, of the judge's finding that Dad must have known by that point that this was all lies. The suggestion that Jay had been accidentally injured over a course of weeks and months, he knew it was all a lie. But the court doesn't play into that assessment of father and then into that finding that, of course, Jay does go back to hospital. There is no recording of father's behaviour at hospital at that point as being abusive or aggressive. And the court recognised and recorded the evidence. It's at E18 of the bundle, and it's paragraph 107.
Sorry, give me the page again.
It's E18 it's part of the judgment. I apologise. It's E21, and it's paragraph 146. So the assessment of the judge, paragraph 146, must have been obvious to father they had to return to hospital, which of course they did. He'd been rude on the telephone. F said that he'd apologised for his behaviour. When he arrived at hospital, Dr. DJ, though, had no recollection of an apology, nor was one recorded in the hospital notes. Of course, the judge finds that the father hadn't apologised. But what is recorded in the judgment is the fact that on father's return to hospital, there are no concerns recorded about his behaviour. There is no evidence of anger. Whatever frustration he felt on the telephone was not demonstrated in his personal presence. And the court also had, and records in the judgment, how father behaved when he was arrested in hospital. The very fear that had driven him to be so rude on the telephone and angry, the fact that something was going to happen, that his family was going to be separated, that comes to pass when he's arrested. But his instinctive reaction is to ensure, it's recorded on the body cam footage, to make sure that Jay is well settled. He expresses his concern that Jay will be on his own for the first time and then accompanies the police officer. And that's not played into the judge's assessment. So the judge has picked, we say, all the negatives about what came out of the 5th of June, father's behaviour. He doesn't balance those, we say, appropriately against the positives. We also would say that he fails to properly understand how difficult the 5th of June would have been for both mother and father. The focus is on father's behaviour. It's not to excuse how rude he was. The judge rightly identifies the fact that the father had no right to be angry with the hospital.
The judge's main point is that the child wasn't taken back to the hospital until there was a threat of calling the police. That's his main point.
Well, indeed.
From that, he infers,
Yes.
because father was protesting, that father had something to hide.
Well, we say that's a jump too far.
But why isn't that a permissible inference?
Well, a permissible inference, yes, of course, because the court is permitted to draw inferences from evidence, but we say it's an inference too far, simply because the father is told, well, if you don't come back, we're going to call the police. And in fact, that the medical records don't actually show that there was a referral at that stage to the police.
No, there wasn't. But the point the judge is making is that responsible parents would have taken the child to hospital. They did not do so until there was a threat of calling the police. And from those two findings, he infers that father must have had something to hide.
But my lord, what we say is that when the court assesses the surrounding evidence for father, that becomes less of a permissible inference to draw. So yes, in isolation, and indeed if it had been accompanied by evidence within text messages or other circumstantial evidence to whether father knew, then so be it, a permissible inference it might well have been. But we say in the absence of all of that, and there is a considerable, and there was a large amount of evidence of the communications between mother and father and others. So had there been, we would have found it, we say, and there hasn't been any evidence of the kind found. So yes, in theory, my lord, it's of course a permissible inference, but we say that in practice, in this case, we say it's an inference too far. Because, my lord, the evidence in respect of matters, the father is fully engaged with the mother in securing that protective covering for the radiator. Both parents and the communication between them supports it, identifying the need for that protective helmet. The father indicating in a text message on the 5th of June when he's told by mother by text that the child's bumped his head in the cot. The father said, you've got to be careful to make sure if we can't be around him that he's got his helmet on. All of that is the behaviour of an individual who understands, we say rightly and reasonably, that the child has had an accidental bump on the head.
Yeah. My concern, Mr. Nuvoloni, is that the submissions that you are making might have been very powerful to a trial judge finding the facts. But we are an appeal court. And even if we think that we would have come to a different conclusion on the facts, that is not enough to set aside a judge's finding of fact. And as you know, it is not generally a valid criticism of the judge that he hasn't balanced the evidence, provided that his finding has a rationally supportable evidential basis.
My lord, of course, but it's the very concluding remarks that my lord makes that we say is that when the court looks at all the evidence, and it had it all before it, to make a finding that father must have known at some point, because the court doesn't go beyond that general assertion. He doesn't analyse through the chronology of the text messages, well, it has to have been before this date, it should have been after that. He just leaves it at a general point. Our assumption is that it's sometime on the 5th, because as my lord rightly says, he seems to land on the fact that the child only returns to hospital after the threat of the police. But earlier in that day, there's we would say clear evidence that the father didn't know anything other than accident. Now, of course, father's submissions rise and fall with the submissions made by my learned friend on whether this is an accident or not, and I align ourselves with submissions made in respect of the judge's assessment of the medical evidence. I don't seek to report or repeat or reiterate any of those points. But yes, there's clearly a high hurdle. We don't suggest that, other than the issue perhaps of those grazes, that the court didn't have all the evidence before it. And we pointed in submissions to why we said the judge should favour our position. But we say that in the round, when one looks at it all, the judge has gone too far. He's gone outside what is reasonable in terms of that finding in respect of the father. And because, as my learned friend has indicated, a parent who may have failed to protect because they did not know is different to a parent who has deliberately failed to protect, deliberately known of a risk and done nothing to protect. And of course, the consequence of the judge's findings for the father is that, well, the father must have continued in his lies. He has conspired with the mother to maintain those lies. And those are very significant consequences in terms of ongoing risk that arise from that one line in the court's judgment that the father at some point must have known. And such a significant finding, we say, should have had more analysis, and that proper analysis would have, in the round, allowed the judge, we say properly, to conclude that the father did not know. My lords,
Wasn't the judge's finding about the father very significantly influeed by the lack of curiosity that the father appeared to have shown in the mother's account of what had happened, her witness statements, and the judge's incredulity that the father hadn't ever really spoken to the mother about this?
it's the transcript, my lord. It's T142.
Thank you.
And it's where the father, in cross-examination by the local authority, accepts that he never questioned her accounts.
Letter.
It's letter, just below letter H.
I've never had to question her.
On her accounts, because I've never even questioned. She's never given me any reason to distrust her the whole time we've been together. So he accepts those accounts, he doesn't go behind them, and he gave the explanation as to why. Of course, the father wasn't there in April, he wasn't there in June, and so in the situation where he hears an account from his wife, the mother of his children, she's never given him cause for concern, and he could see no reason why she would lie about those accounts. And so that's what causes concern, but we would say actually, when one looks at the circumstances, the background and the history which the court was well aware of, we would say it's not an unreasonable position for the father to have taken. He heard an account from the mother, he heard another account from the mother. He's critical, if one wants to put it that highly in his text message, saying, well, we bought that protective helmet for a reason. We're not supervising him, put it on. He is allied with the mother. He goes to the hospital. His behaviour, other than on the telephone, is recorded as being entirely appropriate throughout. He has no cause for doubt, we say, or suspicion about the mother. And so the court again took it too far if he found his finding that father must have known on the basis that he didn't question the mother. My lords, we recognise clearly that the difficulty in the court not only considering how a court focuses on findings of fact, but then finding fault to the extent that they should be revisited. I think on the point my lord made about what happens if this court is satisfied that there was an unfair hearing, we would say, as my learned friend Mr. Bagshie, King's Counsel, has indicated, you can't pick and choose. If it's an unfair hearing, the well is poisoned and we have to revisit it. Not necessarily in the same way. We now have the advantage of those transcripts of evidence. There are ways matters can be dealt with significantly differently. But we say that ultimately what happened was unfair, the findings are unfair, and there needs to be a revisiting of those allegations and those findings on the basis of the evidence that the court heard. Well, unless I can assist further, we've set it out in writing. There's also the written submissions that we
Sorry.
prepared. I'm conscious that in the bundle are written appeal submissions. There's a copy, I think, which has a yellow reference to please insert bundle references to our submissions. We have done that. We've done a new copy and we'll email that in if we may in short order.
Thank you very much, Mr.
Thank you.
Yardley. Mr. Paul?
Thank you, my lords. Well, on behalf of the local authority, as my lords know, the local authority is drawn, and we say it early on in our documents, to the wording of Lord Justice Baker when giving permission. And my lord, as you've read, his lordship said that this judgment, the judgment we're looking at in such detail from His Honour Judge Marin, is a thorough and well-structured judgment. And I start at that point, my lord, because that is fundamentally the local authority's submission, that this thorough and well-structured judgment is not one which requires this court to interfere and to overturn any of the findings that have been made and order what you've heard from my learned friends would entail a retrial. Both of my learned friends have said, both Mr. Bankshire King's counsel in oral submissions, that they don't gloss over the obvious hurdles that he needs to overcome to succeed in this appeal. And equally, my learned friend Mr. Nuvoloni in his skeleton argument accepts that the father faces significant challenges in seeking to undermine the findings of fact. The case law is very well known to this court, my lord, has dealt with a number of the cases. I won't repeat any of the points that have been made and are clear in the authorities. My lord, can I just very, very briefly just set the scene why I say on behalf of the local authority that this judgment is thorough and well structured, and then come on really the focus of what we've heard in oral submissions, being ground two of mother's appeal and the points made by my learned friend on behalf of father. Firstly, I don't need to remind this court of the task of the lower court. 11 days of evidence, written submissions ordered on the agreement of all parties. You have all seen detailed written submissions from each of the parties. And as my lords have observed, a day then set aside for oral submissions at the election of each of the parties to respond to matters raised. We then, all aware that the learned judge was about to go on leave, we then received a judgment 21 days later in draft form, and the draft form is pretty much intact, the version that becomes the perfected judgment. It is clear that there's no delay between the learned judge's consideration and...
Pause a moment. Did anybody object to the draft judgment insofar as it was making findings about the grazes?
Not that I recall. I think the only if there were at all any matters, there were typographical issues. No, there was no...
Nobody said, well, hang on, Judge, you shouldn't be making that finding.
No request for clarification on the point, and I appreciate we have to be careful about clarification rather than asking for matters to be re-looked at. But no, nothing raised. And then, of course, in the chronology of the lower court, a hearing relatively soon after the delivery of judgment to case manage the case and also then deal with the permission to appeal applications that were made orally and refused by the learned judge. Just in relation, if I may, so that it is in the forefront of this court's mind, as far as you've read at paragraph 9 of the judgment, the transcript, that the learned judge said the material in this case is extensive and contains a number of files. Simply make that point because it is right that I think my learned friend Mr. Toomey King's counsel puts in his skeleton argument that the learned judge was dealing with something in the order of 4,800 pages. There were indeed 6 bundles before the lower court, a core bundle of 1,405 pages, a police bundle of 553 pages, a medical bundle of 849 pages, a photographic bundle of 243 pages, a digital forensic analysis bundle totaling 1,799 pages, and a contact notes bundle totaling 225 pages. I simply say that because that is the extensive evidence that the lower court was dealing with. And it's from that wealth of evidence that it is very clear in my submission from the learned judge's early remarks in his judgment that he has read and considered so much more than he contains in what I still maintain is a very detailed and thorough 34-page judgment. So clearly, everything that the judge has read is not going to find its way into that judgment. And my lords will have seen the various passages where the learned judge makes reference to, even if I'm not mentioning individual points, I have taken them into account. The thorough and well-structured judgment in my submission is borne out simply by going through the efforts that the learned judge makes to bring together the important factors. So we have paragraph 16 to 64 dealing with this assessment of the background. We have a clear and unchallenged assessment of the law from paragraph 65 to 82. We have a clear, in my submission, and well-structured setting out of the medical evidence, paragraphs 83 to 108. We then have the learned judge's conclusions of the medical evidence from paragraphs 109 to 135. And then we get on to the lay witnesses, and my lords will have read, and it doesn't form part of this appeal to any great extent, but my lords will have read that the learned judge heard some lay witnesses. They were described as the broad or wide canvas witnesses setting the scenes, and the learned judge sets out his assessment of that evidence from paragraphs 125 to 135. And then we get on to the evidence of the parents from paragraphs 136 onwards, before the learned judge reaches his conclusions. I set that out in just that detail because, my lords, in my respectful submission, it is clear the efforts that this judge went to deal with all the relevant and significant aspects of the evidence that he was then going on to look at and to factor into the conclusions that he came to. My lord, in earlier exchanges, just to focus on the medical evidence. In earlier exchanges, my lord, rightly in my submission, identified that what was left by the end of the medical evidence was in effect a binary decision. And indeed, that was not a surprise, because that's where the doctors were at the experts meeting. And I say that because it's clear, without going into the full bundle, but you've seen, my lords, at paragraph 95 of the judgment that
95 of the judgment.
Of the judgment, yes, it's at E15.
Yeah.
The learned judge is quoting from the meeting, from the experts' meeting. And at the very end of that passage in italics, the end of paragraph 95, we have really exactly where the medical evidence took us in this case. And really, in my submission, the final paragraph, final sentence really just deals with it. Now, the other way, the scalp swelling would be unusual, but they both kind of seem as two possibilities, which eventually, I think, is not down to us to make that call.
When you say binary, you mean binary in respect of the injury sustained for the incident on the 24th of April?
Yes.
It's not binary in respect of all the matters relied on by the legal
No,
authority.
no, and I accept, my lord, that there was, and indeed the learned judge accepted, that there was a possibility of a hybrid,
Yes.
which would open up the possibility of some inflicted and some accidental.
Thank you.
But certainly, my lord, and I'm grateful because that, of course, focuses the minds at the 24th of April, because clearly the evolution point, so the evolution of injuries as being the full explanation, requires an acceptance that the 24th of April was in itself an accidental injury. And so, my lord, where we were at the end of the first week of the trial, the end of the medical evidence, is in effect where we were at the beginning, as far as, in my submission, as far as bullet points, headlines, that we can take from that experts meeting.
Is the analysis of, summary of Dr. Caldwell's evidence, is that set it out quite well in 97? That subgaleal hematomas are uncommon.
Yes.
Shearing force, some of Jay's injuries could be non-accidental, some accidental, and then if M's account of 24th of April was accepted, he could explain the injuries to Jay that day.
Yes. And then from there, and then that, in my submission, my lord, takes us over then to where the judge comes in from paragraph 109 onwards, and from 113, the bullet points, as it were, of the conclusions that the learned judge was, in my submission, perfectly open to draw from the medical evidence, having by then had the benefit of the written reports, the questions put to the experts meeting, permitting the experts to all give oral evidence, or all those that were required to give oral evidence, and then we get the conclusions based on bringing all that evidence to the forefront, clearly, of the judge's mind.
And at 118, he acknowledges that it could be what he describes as hybrid.
Yes, yes, absolutely, absolutely. So, my lord, we have a clear picture in my submission by the time we get to that crucial part of the trial that are of utmost importance, and this, of course, reflects back on well-known authorities, of utmost importance in a case such as this will be the evidence of the parents and the court's evaluation of the reliability and credibility of the evidence given by both parents. There can be no doubt that we were all of the mind that that was where we were at the end of the medical part of the case. As far then as the parents' evidence is concerned, and I turn really with Moylan from Mr. Bagshey King's Counsel's second ground in mind, we get to the stage where the learned judge is, and of course great attention is paid to ensure that both parents have the opportunity to give their full evidence. You've seen from the transcripts there were breaks at certain times. It was clear in the arrangement of the case that a day would be set aside so that the parents' evidence would be capable of being given, and they could have the best opportunity. It was clear when they were to give their evidence, so there was no surprises to come. And then, and you've read transcripts, and you see that the parents both gave their evidence. Of course, by the time the parents gave the evidence, they'd had the opportunity to listen to the medical evidence. But it is clear in my submission that when turning to the second ground from mother's point of view, this idea that the judge imposed or for the first time in his judgment, what we see is a case theory that's been advanced by the judge. I would certainly caution any reading. The genesis of this argument comes, as we know, from paragraphs 173 and 174, E25. It's my overarching submission, my lords, that reading into 173 or 174, a suggestion such as that photograph or the grazes was conclusive is clearly not borne out when one reads the whole of the analysis and indeed the whole of this part of the judgment. Before we get to those points made and the mention of the photographs, we've read from 165 onwards, and I think Moylan from Mr. Toomey, King's Counsel, describes it as a headline of what the judge then goes on to articulate. The judge is setting the scene for his description of the mother's evidence as unsatisfactory and worrying. And he then, from paragraph 168 onwards, goes through in detail in my submission, clear and compelling detail, 6 inconsistencies in the fundamental aspects of the evidence.
I counted 8.
You counted 8. Well, my lord's probably right and my sums are probably wrong. But yes, my lord has the point. He goes through each of these key aspects of this. This is the 24th of April, of course. And this is, and the points made elsewhere in skeleton arguments, that of course this is a mother who says she saw everything. you've read in her transcript, she's saying, I have a very good recollection. And what we have, and my lord I'm sure is right, is 8 examples of key details that are clearly not consistent. I don't accept the point, if it is pursued, that cross-examination of the radiator point, whether the radiator was switched on or not, in itself is going to lead to a confused or mistaken answer because she was asked for the first time in the witness box. I simply don't accept that. It seems perfectly obvious that if the argument is a mother, a vigilant mother, this is the cross-examination as you've read, a vigilant mother, skilled in safeguarding, is watching a child who has just, or maybe for a few weeks, been crawling, heading towards a hot surface, it would seem an obvious thing to intercept. That was the point I put to mother in cross-examination. So that is a factor that, of course, mother was asked to answer, and as we read in 172, gives, in the learned judge's view, a totally unsatisfactory response. My lords, it's only when one goes through that part of the judgment and when one looks at the learned judge's clear, I respectfully submit, analysis of those key factors of the evidence about such, really the start of all of this, the vital detail about what happened on the 24th of April. It's when one goes through that one then gets to paragraphs 173 and 174, and I do not, in my submission, accept that it's simply pulling out the photograph and elevating that to say that was the clincher, that was the factor upon which the learned judge made that call. It's simply not borne out in my submission by a clear reading of that judgment. My lord made the point that the photograph was flagged in my learned friend Mr. Hussein's closing submissions. And we know, and it's common ground, that it was, and this is on the fairness point, it's common ground that the opportunity was there, and my learned friend Mr. Bankshire King's counsel quite clearly, of course, takes, as he says, responsibility for that. That could have been explored if it was of concern at the oral submissions. The question of inconsistencies, and my point is linked, of course, that this is not, it's not just about a photograph, it's about the totality of mother's evidence and the inconsistencies determined by the court. And my lords have read in the local authorities' closing submissions, and we have that at D41 of the core bundle. The D41 electronic 156, in considerable detail, we had set out in our closing submissions the areas that we invited the learned judge to consider by way of inconsistencies in the mother's evidence. And a number of those factors form part of the findings that we read from 167 onwards. So it can be, again, in my submission, no surprise that the learned judge was invited, and of course, central in the task of the learned judge, given where that case was at, was to consider the reliability and credibility of both parents. It can be no surprise that the local authority, and indeed the Guardian, were raising issues about the reliability and credibility of what had been heard from, in this case, the mother. So, my lords, fundamentally, I do not accept the submission, and I'd invite you to reject the submission that my learned friend Mr. Bankshire makes, that it was, the photograph was a clincher.
But can we just go back a step? The doctors were not asked about the cuts. Is that right? In other words, it didn't feature in either the written evidence, the experts' meeting, or the oral evidence.
the the doctor, certainly, my lord, at the experts meeting, had seen a lot of photographs. One feature that with the case management of the learned judge and the cooperation of all parties, we had to try and arrange between the experts meeting and the trial, was that it appeared clear that certain doctors were looking at different photographs.
Yes.
And we had then an agreed photographic bundle, but they were all sent. I'm sorry, my lord, I'm interrupting you. Sorry.
No, go on.
They were all sent in the end before the trial. All the doctors had been sent a photographic bundle, which is a full bundle, which is the one that runs to those so many hundreds of
What
pages.
I'm just trying to get is your submission that what the judge says in 173 is that the he calls them graziers doesn't fit with the mother's
Yes.
account, and he repeats that in
Yeah.
223. He said the photographic evidence did not fit her description of what happened on any basis. There was no medical evidence to that effect.
No, I did. May I just turn around very briefly? My lord, save that the doctors had all had a bundle of photographs and been asked if there was anything they wanted to comment on, but no, we did, not from my recollection.
So what we have from the doctors of Dr. J. Marin in 94B is that there was an impact such as the one the mother described.
Yes.
And as we saw earlier on, Dr. Cardwell, if mother's account is accepted, it could explain.
Of course, the caution being mother's account.
I understand all that. What I'm just trying to get is your submission on the judge's conclusion that graziers don't fit with falling onto a radiator, and that the photographic evidence did not fit a description of what happened on any basis. I'm just trying to explore the evidential foundation for those conclusions.
Well, I would respectfully suggest, my lord, that it goes back to those points made from 168 onwards about the mother's various accounts of the contact with the radiator, and we don't, from there, have a clear picture of a simple, maybe, and I'm speculating now, but maybe some form of sliding down a radiator without the cover on the radiator, which we understand that parents say wasn't there, giving rise to those grazes.
A mechanism is always an important feature in a case of this sort.
Yes.
But that was not a feature of the mechanism in the sense that was explored in the evidence. As to whether what's seen there is consistent, is inconsistent, or anything of that sort.
I don't recall that forming part of an input to the doctors. What, of course, my lord, as well as the confusion about whether it was the correct photographs, there was an issue that some photographs, of course, were taken in the hospital, some were police photographs. We didn't have a clear picture of the quality of all of the photographs. And so there hadn't been, I think I tried to say, there hadn't been a request for the doctors to look at that specific photograph with the view of forming a distinct view or mechanism on that photograph. So, my lords, it's my fundamental submission that we are looking at wording in these paragraphs reflecting on the photograph. I accept the points that are made about the photograph to the extent that it is, as my lords identified, not something that we could say the doctors looked at and particularly commented on as a mechanism.
I'm so sorry, Mr. Paul, to interrupt, but I was just looking back then at Dr. Jennahan's report, electronic 354, page E326, I think, in the bundle, paragraph 3.4, where he alludes to the quotes overlying greys, singular, but no significant cut. That's the one we're all focusing on, is it? I draw it to your attention in the sense that he plainly had it in mind,
Yes.
doesn't appear to draw any conclusion from it one way or another.
I'm just hesitating, my lord, because I am relying on memory of where we were up to at the time of his report as to the actual photographs and how many had been collated. But it would certainly, from my recollection, the only grazing style injury would be consistent with him having seen the photograph that we're talking about.
Thank you.
So, my lords, I'm left in the position of inviting my lords to conclude that this is not a compelling and a clinching, the photograph is not a clinching factor for his honour. It is one of but many factors that he took into account. It is the mention of the photograph is to be read in my submission clearly in the context of all other points made, not least the points that we've alluded to of the significant inconsistencies. And on that basis, and certainly as far as the strength of the submission, I'd invite my lords, as to the clinching factor, I'd invite my lords to reject that. And then going on to the furnace point, I think my lords have already identified that the furnace is not made out in my submission on the basis that there was every opportunity, if this was to form part of a response to submissions, to have been made. My lords, I think it's right from the submissions that we've heard that is the primary focus of the mother's submission to this court. My lords have in my skeleton argument the response to other grounds that have been raised. I don't think there's anything being pursued now on the burden of proof. I don't need to remind my lords that the learned judge deals with, in my submission, a very clear and very well set out consideration of all the legal principles, and it's abundantly clear from his judgment that he has in mind and makes very clear the burden of proof and the difficulties, the uphill struggle, I think my learned friend describes it as, is clearly one that we don't reach. My lords, you've heard about the unusual features of the injury, and I don't perhaps need to go into to that in any more detail than you've read in the skeleton arguments, but it goes really back to the points that are made in the judge's conclusions as to where the medical evidence takes us, and it is abundantly clear when one goes through the entirety of the learned judge's judgment that he recognises how unusual either of the main options, so by the main options I'm talking inflicted, or at least some inflicted injury, or accidental. And that embraces the point that's made that there was no underlying head injury, and that is well rehearsed in the evidence and indeed in the judgment. And indeed, paragraph 118 is an example of where the learned judge clearly reflects on the fact that there's no absence of brain injury or skull fracture is a feature in the medical evidence, but of course it's a feature that is well recognised by each of the doctors in their own from their own discipline. As far as the submission that the learned judge, having made the findings that mother had inflicted injuries on the 24th of April, simply then went on to make all the other findings about mother on the basis that if she's done one, putting it in the vernacular, if she's done one, she's done them all. I'd respectfully say that it's abundantly clear from the judgment that the learned judge goes through in detail each of the individual points And indeed, when one focuses on, for instance, the music box, you've read, my lords, about the music box and the presence of the music box in the child's cot, and this is when we're talking now about the June injury. The learned judge does not accept the local authority's case on that, that in some way there'd been, maybe the music box had been put there, or indeed other items had been put in the cot to form, to effectively set things up. And so it is clear that the judge is not wholesale just accepting, having made one finding, he would make them all. And I'd invite my lords to reject that suggestion as it applies to everything, having made the findings from the 24th of April. My lords, turning to the father's points.
Sorry, insofar as the other injuries are concerned, where does the judge deal with the option of they might have been caused through normal handling because of the vulnerability created by the first injury?
My lord, I'm sorry, just bear with me, if you would. My lord, I hesitate. I was just going back to his conclusions on the medical evidence, but in the overall conclusions, my lord, at paragraph 215 on E29, he's touching there, of course, on the fact that they could be as a result, the injuries could be as a result of an accident that's evolving. 216, he makes the point that can't be dismissed. And it's certainly, from his conclusion of the medical evidence, he was certainly drawn then, I think it's right, and it goes back to 118 about the underlying, lack of underlying brain injury as a factor in the seriousness of what would be needed beyond an initial assault. My lord, I think 215 is where we get something of his views on that. And then, of course, it moves forward. He reflects, I'm sorry, I was thinking about this point. He reflects at 243, none of the medical experts rule out non-accidental injury caused by one or more or multiple impacts, albeit by a lower level of trauma, before moving into the medical evidence permits the findings. My Lord, turning then to the points made by my learned friend for father. Much is made of the challenge, of course, is made of the findings made in relation to father's knowledge. And my lords, it's the lack of curiosity, and that's clearly in my submission borne out by paragraph, if one considers paragraph 219 and 220 at E30. This is paragraph 220, despite father being a person who felt able to tell mother freely what to do and do as he liked, it made no sense that he never discussed the events surrounding Jay's injuries. In my submission, that really crystallises the lack of curiosity point, and that is a feature that we see from the judgment and an assessment that the learned judge is perfectly entitled to make in my submission of the father, having heard the evidence. And once, when one reads the transcript, it's clear that it was put to both parents, the discussions they'd had, whether they'd read each other's statements, whether they'd seen each other's police reports. So it is, in my submission, a perfectly permissible inference to draw that the father did know more than he accepts, and indeed that is in the context that we are looking at a period of time, a period of injuries over a number of weeks, and certainly the idea that there was no discussion of the events surrounding Jay's injuries, that would embrace a whole period where this child has been said to be ill, has been said to need GP attention, has been said to, we know, back in hospital by June, and in a situation where the father and the mother are presenting as a loving, cohesive couple, attempting to do what's best for their child. So with that lack of curiosity in my submission, it is perfectly open to the judge, having heard at length from both parents, to conclude that that the father was indeed very much more aware than he told the court. My lord made the point that this court, of course, may reach a different conclusion, but that is, of course, not the role of the appeal court. One has in mind, really going back to one of the authorities, and indeed it's my Lord Justice Lewison's comment that the trial is not the dress rehearsal, it is the first and the last night. And this was a trial that took place with every account made, every effort made by the learned judge to ensure fairness to all parties, every effort made to do justice to the wealth of evidence, to consider everything that was before the lower court, to consider it all, to piece it all together, to bring together the strands from such an enormous amount of written evidence and oral evidence, accepted by all parties to be an unusual case, a case that the medical evidence really didn't provide the answer. And what was left to the learned judge to do was to take an overview and to assess each of the points, piece them all together, and come up as best able with a cohesive series of findings. He did that in my respectful submission. He did it with every effort made to ensure that the relevant points were considered. He did that, ensuring that parties have the opportunity at all stages to contribute fully. And there's nothing in my submission that suggests that this thorough and detailed judgment should indeed now be overturned to the extent that a further hearing or retrial would be ordered by this court. My Lord, unless I can assist you further.
Just one point, if you wouldn't mind, Mr. Poole. You quite rightly accepted that a judge can't make up his own case theory.
Yes.
That, of course, depends on what the rival case theories are. And the judge refers at paragraph 7 of his judgment that the allegations that the local authority were making were in a Scotch schedule, but I don't believe we've got that.
No, I don't think you have, my lord. I don't think
So your case theory, presumably, will be in the Scott schedule somewhere?
Yes,
I think we may need to have it.
certainly. There's no difficulty in that. I'm not quite sure why it didn't find its way into the bundle, but no, certainly.
Thank you very much, Mr. Poole. Yes, Mr. Twemmy.
I might be briefer than others, but I'm not sure I'm going to be as brief as to conclude by 1 o'clock.
All right.
It was when the trial judge in this case came to consider the 5 distinct points at which the child ought to have been taken for medical attention or was, he had certain written information which told him that this was a child aged 8 or 9 months, depending on the date of the incident, with significant injuries, which on 2 occasions were said to be self-inflicted, at least 2 occasions. And as to which the papers...
Sorry, self-inflicted.
Yes, so the pulling up and falling on the radiator and
Sorry.
falling around in the cot in June. So these are significant injuries sustained by an 8 or 9 month old child to himself. That was the case he was considering. And as to which the papers, without any oral evidence, yielded a number of inconsistencies on the primary carer's accounts. And the papers yielded at least 2 discrete occasions when the mother had failed to permit the child with significant injuries undergoing a full medical examination, the sort of medical examination his condition required. And 1 occasion when she might have sought medical attention but did not, and that's the fall in late April, the 2nd fall. So in relation to those matters, on the mother's own account, written account, there were many inconsistencies. For example, her account of what she said to the GP, her own written account, was inconsistent. She also, of course, on the face of it, the judge knew the GP disagreed with what the mother said before he heard evidence from the GP. And in relation to the departure from the hospital in June, again, the mother's account was inconsistent. She said, in her first witness statement, that she denied that leaving the hospital was contrary to medical advice. Nobody told her otherwise. That's at G61, paragraph 11. But she changes that account in her subsequent witness statement, paragraph PDF 90. Sorry, PDF 472, paragraph 90. I know the local authority concerned I left the hospital with the child against medical advice. That's not entirely true. They only advised me not to go until his bloods. I left after his first blood test was done, so I thought it was okay to leave because they came back clear. They did not specify to wait until the second blood test results come back. So before he had any oral evidence, he had significant inconsistencies to address, significant issues to address about non-seeking of medical attention. And then he had the advantage of all of those points being put to the mother in cross-examination. He had the advantage of hearing from the GP who had given the mother direct advice as to what to do with her child. And so the key to the case turned upon his assessment of the lay, primarily the parents, and most obviously the mother's account, the lay evidence, but also the professional evidence, including from the GP. And so that's why we say in our skeleton that in coming to his conclusions in his fact-finding inquiry, he had the fullest advantage that is envisaged in the, is it Phage or Fahy case?
I always call it phage, but
I thought I'd been wrong for a long time. It wouldn't be a first, but the fullest phage advantage in this trial. So that's the starting point. The second point, if I may, is in relation to the medical evidence. And just want to say a little about the medical evidence and the approach to, first of all, the April incident. So first of all, we'd say that the judge can't be criticised for starting with that incident. Firstly, it's the first in time. Secondly, it may be the consequence of later symptoms. And thirdly, it's, of all of the incidents, one's been allegedly clearly witnessed by somebody before the court. So it was the logical place for him to start. But wherever a judge starts, a judge has to start somewhere. It doesn't matter in our submission whether the judge starts at one particular place or another. What matters is that he ultimately looks at everything in the round. And the judgment in our submission demonstrates this judge did just that. Now, the expert evidence, I'm going to suggest that the appellant's approach to the expert evidence is a little inconsistent in this respect. On the one hand, they accept that the net result of the expert evidence is that it doesn't tell the court whether this incident in April was an accident or might have been an accident or might have been inflicted, and doesn't even assist the court in understanding which of those two propositions is the more likely. And so, if you like, they rely on that as helpful, appropriately helpful to their case. But where I say they can't go from there is to then say, as my friend Mr. Bakshi said in his closing note, but also in oral submissions this morning, that the medical evidence leans heavily towards the proposition that this was an accident. The medical evidence doesn't lean. It is a vertical line, straight up and down. The significance, I suggest, of the medical evidence coming from the paediatric neurosurgeon is that this was a highly concerning injury to a child, a subgaleal hematoma, hemorrhage. And the association of that sort of injury with a significant, usually high level of force would, on the face of it, not match self-infliction by an 8 or 9 month old. What Mr. J. Marin does is he looks at a number of factors which are unusual in the presentation of the child, the way in which the swelling develops over time, the period of the child in hospital in May. And he reflects on all of those matters and concludes a number of points. The first point is that this is a runner. Accident is now a potential explanation. And that's why it helps the parent, because ordinarily a child of this age, self-inflicting to cause injuries of this nature, would be out with the expectation or the advice of medical experts. So the significance of it is that it puts it on the agenda as a possible explanation. It's also significant because it puts it on the agenda with equal force as inflicted, the infliction option. But that's it. That's where it begins and where it ends. And so, for that reason, one could describe the two options, accident or inflicted, either as equally unlikely, which is the terminology adopted by the experts and accepted by the judge, or equally likely. I mean, logically, if there are two options and you can't tell between them, then they're equally unlikely or they're equally likely. They're equal, in other words. So that's why, and there's some indication in the closing remarks on behalf of the mother, that this was not in dispute, but that is why it was clearly not in dispute before the land judge, that what he now had to do was to approach this with an open mind. This could be inflicted, or it might be an accident. And then he begins his inquiry with the 24th of April. And there he was entitled to begin and the conclusions he drew in relation to 24th of April, he was entitled to draw, because at that point, he's now looking at the mother's account, which she gave, and indeed we looked earlier, we were also taken earlier to the transcripts, and it's perhaps of note in passing that when she was asked, I think it's in chief at page 93 in the transcript bundle, when she's asked to give her account of the fall, she says, just over a third of the way down, which the question is how he got from being upright to not upright. Do you still have a memory? And she says, yes, it's stuck in brain. And she then goes on to describe the sliding. So this is a witness who not only saw what she says she saw, but is very clear about it. But just on that simple point, the obvious omission from her evidence is any reference until that point to a sliding mechanism, which of course had only come up in the course of the expert evidence.
And I think Mr. Badgie was suggesting that cuts may have come from sliding down the edge of the radiator, not the wall.
Yes, well, I suppose if we...
It can't just be a bump on the head, because the experts say it has to be a shearing of some sort.
Well, it probably has to be a shearing, yes. It's difficult to know what the mechanism would need to be.
I thought Mr. Bagshey was suggesting that it was the
Forward.
onto the radiator,
Onto
the two whatever you
sides.
call them, bits sticking out.
I mean, the only, and again, I don't want to fall into the criticism or the error that others might be said to have done in their approach to the case, but we do have a picture of the side-on view of the radiator, in fact, which is at M34, PDF 517.
Sorry, PDF
517.
Sorry, what?
M34. M for mother.
I don't have an M.
I have a J.
Just J.
Ah.
I was just checking my
It's
alphabet.
going to be J. Oh, J.
Oh, is it? It's, sorry, that's an old pagination. I'm very sorry. It says M34 on my screen, but
PDF 517.
yeah, but
Oh no, that's one I've got. Sorry.
No, it's H. I think we draw the
It's in the
pagination.
police bundle, actually,
It's
isn't it?
police bundle, H20. It's not paginated in that way, but it's just after H21.
Oh yes, that's the cot.
The next photo.
No, next photo.
sorry, two on.
Oh yes, I see. But it's got its guards on it.
Yes. But it is quite a gap between the two sides.
Yeah.
But as I say, that's the only picture we have of the. So, yes, taking the guards off, but adding the guards to my comments, I just draw that to the court's attention. But, so I think what is being suggested is the child might have hit both sides, both areas. Of course, the original account given was that it was a valve. So it's, I don't know if that's an appropriate time to stop.
Yes, by all means. How much longer have you got to go, Mr. Twomey?
Well, not much longer. I think probably I can finish in 15, 20 minutes.
Right,
Subject to
then
anything the court may.
Plenty of time for reply.
Yes,
Plenty of time for reply. All right, we'll break there till 2 o'clock.
I think it's supposed to be on. Probably the same.